It is now my privilege to introduce you to our speaker today, Chitchai Pansan, a counsel in Tilaki and Gibbons Dispute Resolution Department in Bangkok. Today, Chitchai will provide an overview of criminal cases relating to Thailand's Labor Protection Act, including discussions on potentially responsible parties, types of criminal offenses, and criminal court procedures. And with that, I now turn it over to Chitchai.
Good afternoon, everybody. Today is the second session of the English part of the How Employment Law Forum. And the topic that I'm gonna talk today is about the criminal cases relating to the Labor Protection Act. The reason why we decided to talk about criminal cases this year is because we have been seeing an uptick trend that disgruntled employees sue employers both the civil case at the labor court and the criminal case at the criminal court to put pressure on the employers to pay more when they are terminated. So one of the most common questions is can employment cases become criminal cases in Thailand? And the answer is yes. A special feature of the Labor Protection Act, or the LPA, is that it is a hybrid between private law and public law. These terms are quite technical. It is private in the sense that it is between the employer and the employee, and it is public because the state can intervene how the employer treats the employee. Also, the Thai Supreme Court ruled that the LPA is relating to public order. What it means is that any agreements between the employer and the employee that is less than what the LPA requires become invalid. And moreover, in theory, any violation in the LPA cannot be compromised or settled by negotiation. The legal term for this is non-compoundable. The LPA gives the power to the labor inspector to go to any workplace to inspect if there is any violation. And if they find any wrongdoing, they can give an order for the employer to fix the issue. And if the employer still ignores, they can refer the case to the police. The LPA was last amended in 2019. After this amendment, I could not find any loophole for any violation that cannot be considered a crime under this law. For example, the previous version did not say that payment in lieu of advance notice is a crime. Meaning, if the employer does not pay payment in lieu of advance notice, is not a crime. And I won a criminal case on advance notice payment in 2018. And in that case, the court agreed with us that there is no provision under the LPA that says not paying the advance notice payment is a crime. The court then dismissed the employee's case, the criminal case. After that, this issue must have been brought up to the Ministry of Labor. In 2019, there was an amendment to the LPA adding section 17/1 which says that if the employee is dismissed immediately, the employer must give the employee a payment in lieu of advance notice on the day that the employee is dismissed. This section was then added to the criminal penalties chapter of the LPA at the end of the LPA. I'll show you the amendment that I'm talking about in a later slide. Let's see who can be criminally liable under the LPA. First, the employer for sure. The employer is, if the employer is a company, the company's directors are also considered the employers. If the directors assign the HR manager or the employee supervisor to make any decision in relation to the LPA, then the HR manager or the supervisor would be considered the employer as well. Also in here, the second one, the business operator. The business operator who uses outsourced services. For example, if company A uses company B to outsource some employees because company A does not want to have these employees in its payroll. Company A is not a direct employer, but company A can still be liable under the LPA if company A does not provide equal benefits and welfare to the outsourced employees, the same way that that company A provides to its own employees. Number 3 here is the official, but we will not talk about this in this session. And next one is the directors of the company who gives or does not give appropriate instruction in relation to the LPA. For example, the company does not have any work rules. The directors still did not arrange for the company to set up the company work rules because the directors did not know that the company must have it. So it is considered that the directors have committed a crime under the LPA for failure to establishing the work rules for the company. Yeah. And then the last one here is specifically designed to deal with sexual harassment behavior of the employer or the boss under section 16 of the LPA. We'll talk a bit more on this later on. Let's see the ways or channels that the criminal case under the LPA can be initiated. One, the employee directly files the case with the criminal court. For those of you who are not familiar with Thai law, the victims in Thailand can file a criminal case directly with the court. They do not need to go to the police first or the public prosecutor first. And this is quite common here in Thailand. The employees who would go directly to the court tend to be executive level employees, as they have money to pay the lawyer's fees to file the case. The way it works is that the employees would sue the company as the first defendant, and then the director as the second defendant. After that, the court would give an order prohibiting the director from traveling overseas. If the director wants to fly out, he must seek a permission from the court first. Usually the court would allow the director to fly out not more than 30 days, and he or she must come back and report to the court that he or she is back in Thailand. This is very problematic for a director who travels often, or a director who is due to relocate to a different country, but cannot do it because there's a pending criminal case in Thailand. So basically they're being held hostage in Thailand because of the criminal labor case. Another channel is that the employee can go to the labor inspectors, or the labor inspectors discovered wrongdoing on their own. If the labor inspectors review the facts and decide that the company must pay the employee, but the company does not comply with the order from the labor inspectors, the labor inspectors would then pass the matter to the police. The police then will conduct an investigation, and usually they just rely on the facts that the labor inspectors reviewed, and then the police would pass the matter on to the public prosecutor to file the case with the court. In practice, the employee would not go to the police directly. If the employee does not know what to do and decided to go to the police would then recommend the employee to visit the labor inspector first for consultation. And then the labor inspector will basically just deal with the case, you know. And next issue is the prescription period. Prescription periods is basically the deadline that the case can be filed with the court. Under Thai law, we determine the length of the prescription period based on the severity of the punishment applicable to the offense. This is useful for us to know because we can assess the risks of criminal proceedings based on what we did wrong, basically. For example, if the director did not know that the company must maintain a set of work rules in Thai language under Section 108 of the LPA, and as soon as he knew, he prepared one, you know, and he did that already a year ago, you know. The company does not need to worry about the criminal case anymore because the prescription period is only 1 year and it has expired already. If the punishment is a fine only, or 1 month prison sentence only, the prescription period is 1 year. Now, the prescription period can be 5 years if the crime is punishable by more than 1 month of prison, or up to 1 month of prison, or up to 1 year of prison. The longest prescription period in the LPA is 10 years. And this is because the longest prison sentence is 4 years. And we'll talk about this 4-year sentence later on as well. What I did with this slide is that I grouped the offenses based on severity. If the penalty is small, you do not need to worry about it too much. But if the penalty is higher, you should pay more attention, basically. The fine here is per person. You see the fine on the left-hand column. For example, if the company has 2 directors, the Department of Labor Protection will impose 5,000 baht for each director and 5,000 baht for the company. So for a violation, the first violation here as the example, the total fine would be 15,000 baht for the company and the directors. Let's take a look at the first one, 5,000 baht fine. This is pursuant to section 145 of the LPA. Section 145 says that the employer who fails to comply with section 23 of the LPA must pay a fine of 5,000 baht, up to 5,000 baht. It is quite complicated to read this law because we would then have to go back to section 23 to see the requirement under section 23. Now, when we look at section 23, it says the employer must specify the working hours. You know, something as simple as specifying working hours. If you don't do it, it can be a crime, you know. Normally, the working hours are included in the work rules. If you already have the proper work rules, there is no problem. I have seen a client's HR policy that they wanted to call it work rules. The client said, this is the global HR policy. All countries must follow the same policy. This policy is also very flexible in terms of working hours. So it does not specify the working hours. They are a global company. Sometimes they have to have a call very late at night or very early in the morning, and their employees can also choose to work from home. You know, I thought this policy makes a lot of sense, but the problem is it does not comply with Thai law. The LPA requires that the work rules must be in Thai and contain the working hours and a lot of other things that is required under section 108. So basically this client broke 2 provisions already. One is the working hours and the other is the work rules. Talking about section 23 here, I just wanted to add that our Minister of Public Health, Kun Anutin, proposed to add section 23/1 to the LPA, which says that if the employee wishes to work from home and the type of work allows such arrangement for the employee to work from home, then the employer must allow the employee to work from home. Currently, it is still a bill, and this bill is in the final stage already for the House of Representatives to consider the wording of section 23/1. It basically added, it basically intended to add 1 section to the Labor Protection Act or the LPA. What is so strange about this is that there is no criminal punishment attached to it. I was thinking if the employer does not comply, then what is the sanction or the punishment, you know? But still, we don't know. We don't have the final version yet. We don't know how it's going to look like in the end. The House of Representatives is supposed to review this law tomorrow. If they have enough time, you know, they might finish reviewing it and pass it, you know. So let's see the final wording of this law. We will keep you posted. And by the way, I would recommend you to subscribe to Tiliki's newsletter and legal updates. We normally send out emails to subscribers when there are any interesting legal updates. Let's talk about the next level of the penalty. The next one is a fine of 10,000 up to 10,000 baht for things like not announcing minimum wages, or the amendment, or not announcing the amended work rules, or or suspending an employee during an investigation. But the work rules doesn't provide that the employer can suspend the employee during the investigation. So this is for the lowest level of penalty under the LPA. Next up, the next penalty is 20,000 baht for offenses like not treating male and female employees equally, not arranging rest period during working hours, or not providing weekly holidays, not providing at least 13 traditional holidays per year to the employees, or not providing annual leave of at least 6 days per year, or things like not paying wages on sick leave days, not paying wages during maternity leave days, which is 45 days in Thailand, and not paying OT to executive employees as previously agreed. Executive employees are entitled to OT if there is a agreed kind of agreement on this. There was a question in the Thai session last week asking if it is a crime for not paying executive employee overtime. The answer is no, it is not a crime, because under Section 65, the employee is not entitled to overtime if such employee is authorized to make decision to hire or fire people. And executive employees can usually executive employees can hire or fire people and can reward staff, However, if the employment contract says that the executive employees is entitled to overtime, then it is a crime for not paying the overtime. By the way, we will give you a copy of these slides, but you will need to complete our questionnaire that we email you after this session. Okay, there is also 20,000 baht fine for offenses like not paying higher OT as previously agreed, not arranging for written consent before deducting wages or salary, not arranging or announcing work rules in Thai, not preparing a register of employees. Something as simple as a register of employees can be a crime here in Thailand. And it is also a crime if you have a register of the employees, but it is not complete. And interestingly, workplace sexual harassment is subject to 20,000 baht fine only. I thought there was something wrong with this, but anyway. Next level is 50,000 baht fine for not establishing a welfare committee. You know, if the company has more than 50 employees, then that company must have a welfare committee. And next is 100,000 baht fine for not treating outsourced employees equally with the company's own employees. Yeah. Yeah, this is the outsource issue that we previously discussed at the beginning. And the next level is 1 month prison sentence, but the fine is only 2,000 baht for not facilitating the labor inspector. You know, when they want to come in and you don't welcome them, you're not cooperating. You know, so for something like that. And for not arranging meetings for the welfare committee is also a crime. Here comes the penalty for the most common labor criminal cases that we have handled here. Violation of section 144, paragraph 1. You know, the penalty is 6 months prison term and or fine of up to 100,000 baht. The most notable one that I briefly mentioned before is section 17/1, not payment in lieu of advance notice. You know, this section 17/1 was added to section 144 in the year 2019. And as previously mentioned, it was not a crime before, but it is a crime now after the amendment. There are also offenses relating to requiring employees to work overtime without their consent, requiring employees to work on holidays without any necessity, or requiring employee to work overtime for more than 36 hours per week, requiring employees to carry heavier than 55 kilos for men or 25 kilos for women. You know, this is, for example, when you check in at the airport and your suitcase is too heavy, and then the airline staff would ask you to carry your own suitcase yourself to the oversized baggage area. You know, this is because of this law. Yeah. Next slide. Okay, this is also section 144, paragraph 1. You can see that all the payment requirements under these provisions, whether it's wages, OT, severance pay, remaining annual leaves, you know, falls under or fall under this section, you know. And usually when the employees go to court, they would go to the labor court to claim severance pay, remaining annual leaves, wages, and something like that, you know, or the payment that they want from the employer. And they would use section 144, paragraph 1 to file the criminal case with the criminal court in parallel to the demand for these payments. There are also other requirements, for example, requiring security deposit from young employees, requiring young employees to work overtime or on holidays. The term young employees here means employees who are between 15 and 18 years old. You know, they're considered young employees. If the employees are younger than 15, you can't hire them. That's against the law. I'll talk about that later on. Also, deducting wages without a consent from the employees. For example, if the employee breaks something in the office, and then you decided to deduct his or her salary, you can't do that without consent from the employee. And then paying wages less than the minimum wages is also a crime. That's pretty obvious. Yeah, not paying severance pay to the retired employees. These are all criminal offenses. Okay. This slide has the highest penalty rate under the LPA, and this is something that the employers should pay more attention. Basically, the first one, 1 year imprisonment and or 20,000 baht fine for obstructing the labor inspector from working. For example, if the labor inspector was told that there are some violations happening here at this company, and they want to visit your company to inspect the working conditions, or to see the work rules, or to visit the employees to see if they are well, but you instruct your security guard not to allow them to enter. That is considered a crime, punishable by 1 year prison term and or fined up to 20,000 baht. The next one is 1 year imprisonment and or a fine up to 200,000 baht. This one has to do with the provisions relating to safety. For example, requiring employees to carry things heavier than 55 kilos, and that violation caused injury to the employees. So for section 144 paragraph 2, an element to the crime is that there must be proven injury to the employees in order for all the criminal elements to be complete and for the judge to rule on the case. Another example is requiring a female employee to perform dangerous work, and they have a list of dangerous work that female employees should not do. But you ask the female employees to do it, and then there is injury to the employees. Then it would be considered in violation of section 144 paragraph 2, or requiring pregnant employee to work overtime. This is an interesting issue. There was a question: what if the pregnant employee is an executive level employee, and for executive to work overtime, it is normal. The law provides that executive level employees, if they're pregnant, they can work overtime as long as it doesn't affect the health of the mother and the baby. So yeah, so executive levels employees still have to work overtime, although they're pregnant. Or another violation here requiring an employee to work overtime. This one means any employees, and such overtime work affects the health of that employee. Yeah. So, and then the higher level is 2 years imprisonment and or a fine of up to 400,000 to, no, sorry, or a fine between 400,000 up to 800,000 baht for using child labor or requiring young employees to perform dangerous work. As I said before, young employees means employees who are between 15 and 18 years old. They are considered young employees to perform dangerous work. And they have a list of dangerous work that young employees are not supposed to perform. Usually this is not a problem. We haven't seen a problem on this so far. Or requiring young employees to work in a slaughterhouse or a gambling house or nightclubs, you know, these are not allowed. And then the highest level of punishment, as I mentioned at the beginning, is 4 years prison sentence and or a fine between 800,000 to 2 million baht, you know, for requiring young employees to perform dangerous work, you know, similar to the previous section. And the employees suffer injury to their health. Yeah. And also requiring young employees to work in a slaughterhouse, gambling house, or nightclubs and such work cause injury to the young employees' health. Okay. This is the last slide already. The last topic of today is how to stop a criminal case under the LPA. One might think that the easiest way is to comply with the LPA, and basically that's it. You know, you don't have any criminal liability if you comply with the law. Well, it is easier said than done. If there is a case, we just have to handle it, you know, because this law is very tedious. You know, it has a lot of details for the HR team to follow, and so, you know, if there is a problem, we just have to handle it. We just have to deal with it, you know. It's not as scary as you would think. I'll explain why. For getting rid of the case, you know, if there is a case, it is easier to get rid of the case by just complying with the labor inspector's order and pay the fine. If the case goes to the police will convince the company to pay a fine again, you know, first at the labor inspector level, right? They convince you to pay the fine. If you don't pay, they'll pass the matter on to the Director General of the Department of Labor Protection. And then the Director General will convince you to pay the fine again, you know. And then if you still don't pay, then they'll send the matter to the the police. And the police will convince you to pay the fine because they don't want to work on the case. And they'll tell you that this is so that the directors do not have a criminal records. You know, if you pay a fine, there is no criminal records, just get rid of it, you know. And so it will not be a problem when applying for a visa or work permit. But after the case has already been filed with the court, it is a bit more complicated to stop the case. If the labor inspector issues an order and you're not happy with that order, you can sue the labor inspector at the labor court. If the court agrees with the labor inspector and the court orders you to comply with the labor inspector's order, and you decided to comply with the order, then your criminal liability will automatically disappear. And what if the employee files his or her own case with the court directly? You know, if the employee later decides to withdraw the case after having filed the case with the court already, and then later decided to withdraw the case is gone as well. Although in theory, the public prosecutor can refile the case because it is not compoundable. Under Thai law, you know, if it's not compoundable, then the public prosecutor have the right to file the case again, although the victim decided not to pursue with the case. In reality, we have never seen a public prosecutor refiling these type of cases. They have too much work to do already. They don't need more work. In the cases that we have handled here at Tiliki, most cases were filed by the employees who filed criminal cases in addition to the civil case at the labor court. Some judges at the criminal court would put the criminal case on hold pending the outcome of the civil case at the labor court. You know, some judges may prefer to continue the criminal case in parallel with the civil case at the labor court. You know, it is well known that the judges at the labor court are so good at mediating the civil cases. You know, they would pressure both the employers and employees to settle the case. You know, usually, if the negotiation is successful, the settlement agreement would say that the employee agrees to withdraw the criminal cases within 7 days, for example, and then the employees would have to go to the criminal court and withdraw the criminal cases. To end this, I just want to say that it sounds scary to know that there are criminal liability with regards to labor practices, but there are ways and methods that you can stop the criminal cases.